The increased pressure on judicial candidates to raise campaign funds is unfortunate. But far worse is the impact on the public's perception of the courts. Here are some of the results of a March survey commissioned by the Michigan Campaign Finance Network and performed by the Deno-Nohr polling firm about the public's opinion of the justice system. Of a sample of 600 Michigan residents who voted in the 2008 presidential election, only 23% said they had a lot of confidence in the Michigan judicial system. 46% said they had some confidence, and 24% said they either had little confidence or none at all, with 8% saying they were unsure. So, almost 70% had at least some confidence in the system. That's better than the results to the question, how much influence do you think judicial campaign contributions have on the decisions judges make? To this, 31% answered a lot, 32% answered some, 18% answered a little. Only 9% said they believed campaign spending had no effect at all. So 63% believed contributions have some influence on judges. They doubted that a judge could be fair and unbiased where a political party or litigant donated substantial amounts of money to the judge's campaign. And this, you may know, is the big issue in the Caperton case that's now before the United States Supreme Court. In response to the Michigan Campaign Finance Network survey, 80% said it was very important that all sources of spending for judicial elections be disclosed. And by the same percentage, respondents favored a system of public financing for Michigan Supreme Court campaigns. So clearly, the public perceives that campaign contributions threaten judicial independence and fairness, and the public would favor removing that factor from judicial campaigns. Now, the interesting thing is that when asked if they would favor an appointive system in which the governor would choose judges from a list of candidates deemed qualified by legal professionals and a citizen advisory board, the respondents were much more evenly split, with 49% in favor and 43% opposed. So, while the public is leery of the effect of large campaign donations on the Michigan Supreme Court, it seems that by no means all agree that the answer is an appointive system, even if it were to be a merit selection system. But that split of opinion may reflect an unshakable, instinctive reluctance on the part of voters to give up their ability to elect judges, including Michigan Supreme Court justices. Those who favor judicial elections say it offers an important measure of self-governance to voters that would be lost in an appointive system. They feel it helps keep judges accountable to the public. Those who favor an appointive system, also known as a merit selection system, although not all appointive systems are based in merit selection, argue that it takes politics, money, attack ads, and the resulting perception of unfairness out of the process and restores public faith in the justice system. I agree with the public's desire for accountability, and I recognize that the appointive system, too, has flaws. As you may know, the Missouri system, long an exemplar for merit selection among the states, is now being criticized by some for having become politicized and not being transparent. Critics argue that the selection process in Missouri has remained political, with the politics still there, but simply taking place behind closed doors instead of in the public's view. And there's much to these criticisms. But at the same time, we simply cannot throw up our hands and say that because of these many systemic flaws, we must settle for the status quo and do nothing. Improvements are definitely needed.